A mercenary is a person who takes part in an armed conflict who is not a national or a party to the conflict and is motivated to take part in the hostilities by the desire for private gain. In other words, a mercenary is a person who fights for personal gains of money or other recompense instead of fighting for the ideological interests of a country, whether they be for or against the existing government. In the last century, and as reflected in the Geneva Convention, mercenaries have increasingly come to be seen as less entitled to protections by rules of war than non-mercenaries. However, whether or not a person is a mercenary may be a matter of degree, as financial and national interests may overlap. Laws of War. Protocol Additional GC 1977 is a 1977 amendment protocol to the Geneva Conventions. Article 47 of the protocol provides the most widely accepted international definition of a mercenary, though not endorsed by some countries, including the United States. The protocol additional to the Geneva Conventions of 12 August 1949, and relating to the protection of victims of international armed conflicts. The 8th of June 1977 states, Art 47. Mercenaries 1. A mercenary shall not have the right to be a combatant or a prisoner of war. 2. A mercenary is any person who is especially recruited locally or abroad in order to fight in an armed conflict, does, in fact, take a direct part in the hostilities, is motivated to take part in the hostilities essentially by the desire for private gain and, in fact, is promised, by or on behalf of a party to the conflict, material compensation substantially in excess of that promised to pay to combatants of similar ranks and functions in the armed forces of that party, is neither a national of a party to the conflict, nor a resident of territory controlled by a party to the conflict, is not a member of the armed forces of a party to the conflict, and has not been sent by a state which is not a party to the conflict on official duty as a member of its armed forces. All the criteria must be met, according to the Geneva Convention, for a combatant to be described as a mercenary. According to the GC3, a captured soldier must be treated as a lawful combatant and, therefore, as a protected person with prisoner of war status until facing a competent tribunal. The tribunal, using criteria in APGC 77 as some equivalent domestic law, may decide that the soldier is a mercenary. At that juncture, the mercenary soldier becomes an unlawful combatant but still must be treated with humanity and, in case of trial, shall not be deprived of the rights of fair and regular trial, being still covered by GCIV Art 5. The only possible exception to GCIV Art 5 is when he is a national of the authority imprisoning him, in which case he would not be a mercenary soldier as defined in APGC 77 Art 47 d. If after a regular trial, a captured soldier is found to be a mercenary, then he can expect treatment as a common criminal and may face execution. As mercenary soldiers may not qualify as POWs, they cannot expect repatriation at war's end. The best-known post-World War II example of this was on the 28th of June 1976 when, at the end of the Luanda trial, an Angolan court sentenced 3 Britons and an American to death and 9 other mercenaries to prison terms ranging from 16 to 30 years. The 4 mercenaries sentenced to death were shot by a firing squad on the 10th of July 1976. The legal status of civilian contractors depends upon the nature of the work and the nationalities with respect to that of the combatants. If they have not, in fact, taken a direct part in the hostilities. They are not mercenaries but civilians who have non-combat support roles and are entitled to protection under the Third Geneva Convention. On 4 December 1989, the United Nations passed Resolution 4434, the International Convention Against the Recruitment, Use, Financing and Training of Mercenaries. It entered into force on 20 October 2001 and is usually known as the UN Mercenary Convention. Article 1 contains the definition of a mercenary. Article 1.1 is similar to Article 47 of Protocol I. However, Article 1.2 broadens the definition to include a non-national recruited to overthrow a government or otherwise undermining the constitutional order of a state, or undermine the territorial integrity of a state, and is motivated to take part therein essentially by the desire for significant private gain and is prompted by the promise of payment of material compensation. Under Article 1.2, a person does not have to take a direct part in the hostilities in a planned coup d'etat to be a mercenary. Critics have argued that the Convention and APGC 77 Art. 47 are designed to cover the activities of mercenaries in post-colonial Africa and do not address adequately the use of private military companies by sovereign states. The situation during the Iraq War and the continuing occupation of Iraq after the United Nations Security Council sanctioned handover of power to the Iraqi government shows the difficulty of defining a mercenary soldier. While the United States governed Iraq, no U.S. citizen working as an armed guard could be classified as a mercenary because he was a national of a party to the conflict. With the handover of power to the Iraqi government, if one does not consider the coalition forces to be continuing parties to the conflict in Iraq, but that the soldiers are sent by a state which is not a party to the conflict on official duty as a member of its armed forces, then, unless U.S. citizens working as armed guards are lawfully certified residents of Iraq, i.e. a resident of territory controlled by a party to the conflict, and they are involved with the firefight in the continuing conflict, they are mercenary soldiers. However, those who acknowledge the United States and other coalition forces as continuing parties to the conflict might insist that U.S. armed guards cannot be called mercenaries. National laws. The laws of some countries forbid the citizens to fight in foreign wars unless they are under the control of their own national armed forces. Austria. If a person is proven to have worked as a mercenary for any other country while retaining Austrian citizenship, his or her Austrian citizenship will be revoked. France. In 2003, France criminalized mercenary activities as defined by the Protocol to the Geneva Convention for French citizens, permanent residents and legal entities. This law does not prevent French citizens from serving as volunteers in foreign forces. The law applies to military activities with a specifically mercenary motive or with a mercenary level of remuneration. Germany. It is an offense to recruit German citizens for military duty in a military-like facility in support of a foreign power. Furthermore, a German who enlists in an armed force of a state he is also citizen of risks the loss of his or her citizenship. South Africa. In 1998, South Africa passed the Foreign Military Assistance Act that banned citizens and residents from any involvement in foreign wars, except in humanitarian operations, unless a government committee approved its deployment. In 2005, the legislation was reviewed by the government because of South African citizens working as security guards in Iraq during the American occupation of Iraq and the consequences of the mercenary soldier sponsorship case against Mark Thatcher for the possible funding and logistical assistance in relation to an alleged attempted coup in Equatorial Guinea organized by Simon Mann. United Kingdom. In the United Kingdom, the Foreign Enlistment Act 1819 and the Foreign Enlistment Act 1870 make it unlawful for British subjects to join the armed forces of any state, warring with another state at peace with Britain. In the Greek War of Independence, British volunteers fought with the Greek rebels, which could have been unlawful. It was unclear whether or not the Greek rebels were a state per the Foreign Enlistment Act, but the law was clarified, saying that the rebels were a state. In 1896, a Privy Council report noted that there had been no prosecutions under the Foreign Enlistment Acts and considered them unenforceable. The British government considered using the act against British subjects fighting for the International Brigade in the Spanish Civil War and the FNLA in the Angolan Civil War, though in the end it chose not to on both occasions. United States. The Anti-Pinkerton Act of 1893 forbade the U.S. government from using Pinkerton National Detective Agency employees, or similar private police companies. In 1977, the United States Court of Appeals for the Fifth Circuit interpreted this statute as forbidding the U.S. government from employing companies offering mercenary, quasi-military forces for hire. United States XREL. Weinberger v. Equifax, 557 F. 2D 456, 462, Cert. Denied, 434 U.S. 1035. There is a disagreement over whether or not this prescription is limited to the use of such forces as strikebreakers, because it is stated thus: the purpose of the Act and the legislative history reveal that an organization was similar to the Pinkerton Detective Agency only if it offered for hire mercenary, quasi-military forces as strikebreakers and armed guards. It had the secondary effect of deterring any other organization from providing such services lest it be branded a similar organization. The legislative history supports this view and no other. In the 7th of June 1978 letter to the heads of federal departments and agencies, the Comptroller General interpreted this decision in a way that carved out an exemption for Garden Protective Services. A U.S. Department of Defense Interim Rule revises Instruction 3020.41 to authorize contractors, other than private security contractors, to use deadly force against enemy armed forces only in self-defense. 71 Fed. Reg. 34826. But that interim rule, private security contractors are authorized to use deadly force when protecting the client's assets and persons, consistent with the contract's mission statement. One interpretation is that this authorizes contractors to engage in combat on behalf of the U.S. government. It is the combatant commander's responsibility to ensure that private security contract mission statements do not authorize performance of inherently governmental military functions, i.e., preemptive attacks or assaults or raids, etc. Otherwise, civilians with U.S. armed forces lose their law of war protection from direct attack if and for such time as they directly participate in hostilities. On the 18th of August 2006, the U.S. Comptroller General rejected bid protest arguments that U.S. Army contracts violated the Anti-Pinkerton Act by requiring that contractors provide armed convoy escort vehicles and labor, weapons, and equipment for internal security operations at Victory Base Complex, Iraq. The Comptroller General reasoned the act was unviolated, because the contracts did not require contractors to provide quasi-military forces as strikebreakers. Yet, on the 1st of June 2007, The Washington Post reported, a federal judge yesterday ordered the military to temporarily refrain from awarding the largest security contract in Iraq. The order followed an unusual series of events set off when a U.S. Army veteran, Brian X. Scott, filed a protest against the government practice of hiring what he calls mercenaries, according to sources familiar with the matter. Though Scott had filed the protest at the Court of Federal Claims, the court order was the result of other bidders intervening in the case. Scott did not submit a bid, however, when the bidders who did submit a bid tried to protest at GAO. The GAO bid protests were dismissed due to the fact that Scott had filed a case at the court and deprived GAO of further jurisdiction in the matter. Scott's case had been dismissed at GAO and was eventually dismissed at the court. The court order was in response to one of the legitimate contractors, and Brian X. Scott had no role in obtaining that order. The contract, worth about $400 million, calls for a private company to provide intelligence services to the U.S. Army and security for the Army Corps of Engineers on reconstruction work in Iraq. The case, which is being heard by the U.S. Court of Federal Claims, puts on trial one of the most controversial and least understood aspects of the Iraq War: the outsourcing of military security to an estimated 20,000 armed contractors. Gurkha and French Foreign Legion, the better-known combat units in which foreign nationals serve in another country's armed forces, of the Gurkha regiments of the British and Indian armies, and the French Foreign Legion, foreign nationals recruited from countries of the Commonwealth of Nations in the British Army, swear allegiance to the British monarch and are liable to operate in any unit. Gurkhas, however, operate in dedicated Gurkha units of the British Army and the Indian Army. However, although they are nationals of Nepal, a country that is not part of the Commonwealth, they still swear allegiance and abide the rules and regulations under which all British or Indian soldiers serve. French Foreign Legionnaires are formed units of the French Foreign Legion, which deploys and fights as an organized unit of the French Army. This means that as members of the armed forces of Britain, India, and France, these soldiers are not classed as mercenary soldiers per IPGC 77 Art 47, ISNI PGC 77 Art 47 F. Private military and security companies. The private military company is the contemporary strand of the mercenary trade, providing logistics, soldiers, military training, and other services. Thus, PMC contractors are civilians authorized to accompany an army to the field, hence the term civilian contractor. Nevertheless, PMCs may use armed force, hence defined as legally established enterprises that make a profit, by either providing services involving the potential exercise of force in a systematic way and by military means, and/or by the transfer of the potential to clients through training and other practices, such as logistics support, equipment procurement, and intelligence gathering. Private paramilitary forces are functionally mercenary armies, not security guards or advisors. However, national governments reserve the right to control the number, nature, and armaments of such private armies, arguing that, provided they are not proactively employed in front-line combat, they are not mercenaries. That said, PMC civilian contractors have poor repute among professional government soldiers and officers. The U.S. military command have questioned the war zone behavior. In September 2005, Brigadier General Carl Horst, deputy commander of the 3rd Infantry Division charged with Baghdad security after the 2003 invasion, said of DynCorp and other PMCs in Iraq, "These guys run loose in this country and are stupid stuff. There's no authority of them, so you can't come down on them hard when they escalate force. They shoot people, and someone else has to deal with the aftermath." It happens all over the place. If PMC employees participate in proactive combat, the press calls them mercenaries, and the PMC's mercenary companies. In the 1990s, the media identified 4 mercenary companies: Executive Outcomes, Angola, Sierra Leone, and other locations worldwide. Sandline International, Papua New Guinea, Sierra Leone. Gurkha Security Guards Limited, Sierra Leone. DynCorp International, Bosnia, Somalia, Angola, Haiti, Colombia, Kosovo, Kuwait, Afghanistan. In 2004, the PMC business was boosted when the U.S. and coalition governments hired them for security in Iraq. In March 2004, 4 Blackwater USA employees escorting food supplies and other equipment were attacked and killed in Fallujah. In a videotaped attack, the killings and subsequent dismemberment were a cause for the First Battle of Fallujah. Afghan war operations also boosted the business. In 2006, a U.S. congressional report listed a number of PMCs and other enterprises that have signed contracts to carry out anti-narcotics operations and related activities as part of Plan Colombia. DynCorp was among those contracted by the State Department, while others signed contracts with the Defense Department. Other companies from different countries, including Israel, have also signed contracts with the Colombian Defense Ministry to carry out security and military activities. The United Nations disapproves of PMCs. The question is whether or not PMC soldiers are as accountable for the war zone actions. A common argument for using PMCs is that PMCs may be able to help combat genocide and civilian slaughter where the UN is unwilling or unable to intervene. In February 2002, a British Foreign and Commonwealth Office report about PMCs noted that the demands of the military service from the UN and international civil organizations might mean that it is cheaper to pay PMCs than US soldiers. Yet, after considering using PMCs to support UN operations, the UN Secretary-General Kofi Annan decided against it. In October 2007, the United Nations released a 2-year study that stated that although hired as security guards, private contractors were performing military duties. The report found that the use of contractors such as Blackwater was a new form of mercenary activity and illegal under international law. Many countries, including the United States and the United Kingdom, are not signatories to the 1989 United Nations Mercenary Convention banning the use of mercenaries. A spokesman for the U.S. mission to UN denied that Blackwater security guards were mercenaries, saying accusations that U.S. government contracted security guards, of whatever nationality, are mercenaries is inaccurate and demeaning to men and women who put their lives on the line to protect people and facilities every day. In 2013, security firm G4S is reported to be the second largest private employer in the world.